one has supported the charges leveled against the petitioner.
Right. Okay. There is no evidence.
In fact, my lord, there is no evidence.
जब आपने कहा कि मेरे अगेंस्ट कोई एविडेंस नहीं है, तो उसमें आप एक ही शब्द बहुत आपने बोल दिया, बैठो फिर दूसरे से पूछेंगे। नहीं तो आप बताइए कि देखो मेरे खिलाफ इतना है, ये जो काम की चीज तो छोड़ दिया।
हाँ, रिवॉल्वर और
खाली गिरफ्तार करने लगा और कहा कि
मैंने पढ़ा
रिवॉल्वर से शूट कर देता, तू तो हिंदू और मुसलमान होता तो थप्पड़ देता।
उस आरक्षक नागेंद्र मिश्रा ने शराब पिया था या नहीं मुझे नहीं मालूम।
राइट।
अब गाली गलौज कहाँ से हो जाएगी?
गाली गलौज क्या जरूरी है? दारू पी के निकलती है। नहीं, फिर आपने कहा कि कहाँ हो जाएगी गाली गलौज? दारू नहीं पी।
In this case, we have already filed written submissions also, my friend. In addition to that, my respectful submission before this honorable court is that
your guess failed.
Yes,
we
have.
Your guess failed.
I'm sorry, ma'am.
You are apprehending this matter will not reach.
I'm sorry.
Your guess is failed.
I heard on Monday 24 number.
Monday हर दिन का शो अलग होता है. Depends.
I was sorry. I am sorry, much.
Yes, please.
The petitioner was initially entered into service as constable on 27/1985, and after rendering more than 14 years of service, my lord, on 6/12/2001, he was deputed in the Mela duty, and during that, my lord, the petitioner referred to certain antisocial elements to not to organize the gamble. They made false complaint against the petitioner and alleged that he was demanding the illegal bribe and also consumed the liquor. Based on that, my lord, the charge sheet was issued, that is Annex P1, to the writ petition. As many as 3 charges were leveled against the petitioner. May I read, my lord?
Right. Charges. Total charges were
3 charges, my lord.
3 all proved.
2.
Right.
2 and 3.
Annex P1.
Which charge not proved?
Number 1.
Found to
consuming liquor.
Illegal demand of right.
Illegal.
And in respect of the charge number 2, the findings given by the inquiry officer, my lord, may kindly come to the. Without examining the petitioner medically, the findings in respect of charge number
there is no medical to that effect.
No, there was no medical.
And what was the third charge?
Third charge was the consequential, my lord. विभागीय छवि धूमिल करते हुए मध्य प्रदेश सिविल सेवा आचरण नियम 3 के उपनियम का उल्लंघन करना.
Second charge is very important, my lord. Reason being, where he has not only but abused in the name of caste to the other person and threatened the person with the. This is the important.
अच्छा, इसमें जो गाली गलौज का वो प्रूव हुआ नहीं?
हुआ सर, उसमें 4
वो भी प्रूव नहीं हुआ है. In fact, the findings arrived by the inquiry officer are perverse.
नहीं कैसा?
In respect of charge number 2.
आप उसके चार्ज नंबर 2 का बताइए.
चार्ज नंबर 2 बता रहा हूँ मैं. चार्ज नंबर 2, शराब के नशे में होकर जनता के साथ जातिगत आधार पर गाली गलौज कर धार्मिक भावनाओं को ठेस पहुंचाते हुए शिकायत का अवसर देना.
Right.
Finding in respect of charge number 2 is at page, my lord, page number 47, my lord, of the inquiry report. शराब के नशे में होकर जनता के साथ जातिगत आधार पर गाली गलौज कर धार्मिक भावनाओं को ठेस पहुंचा. ये
नहीं, सुनो भैया, नहीं, वो चार्ज शीट दिखाओ, उसमें क्या
चार्ज शीट Annex P1 at page 32. Based on the statements of prosecution witnesses 1, 5, 6, 7, 10. Now the statements of these witnesses, my lord, have been mentioned in this charge sheet, inquiry report itself. Prosecution witness 1 is at page 38, my lord. No one has supported the charges leveled against the petitioner.
Right. Okay. There is no evidence.
In fact, my lord, there is no evidence. And
ठीक है, but that's only for no evidence we will ask him.
My-
Yes.
और एक छोटा सा
My lord.
कंसीजन है हमारा।
I just start with the findings of the honorable court, my lord, and thereafter I will corroborate with the document which has been annexed.
Listen. या तो देखो आर्ग्यू करने का तरीका है, पता है क्या?
मैं एक छोटा
आप सुनो, जब आपने कहा कि मेरे अगेंस्ट कोई एविडेंस नहीं है, तो उसमें आप एक ही शब्द बहुत आपने बोल दिया, बैठो फिर दूसरे से पूछेंगे। नहीं तो आप बताइए कि देखो मेरे खिलाफ इतना है,
मैं वही
ठीक
पढ़
है?
रहा था।
बढ़ रहा था तो आप तो सीधे बोल मेरे खिलाफ कुछ नहीं है,
सब है।
बताइए।
मैं पढ़ रहा हूँ।
हाँ बताइए प्लीज।
विटनेस नंबर 1 स्टेटमेंट
विटनेस
at page 38 my lord,
पेज 38।
Of the writ.
Yes.
inquiry report
Its typed copy is also there.
Which witness you are referring?
number 1 my lord
Number 1.
ने अपने कथनों पर बताया कि 4-5 माह पहले की बात है, इस दशमी के दिन कहानी में मड़ई लगी थी। रात में 9 बजे करीब खेत में सिंचाई करके भगांव से घर आ रहा था। गौशाला चौक पर सामने से एक स्कूटर वाला निकला तो गाड़ी लहराते चला रहा था, तो ये कहकर चिल्लाया कि इसी बात को लेकर सुमन नागवंशी की दुकान में पान खा रहे थे। तब पीछे से नागेंद्र मिश्रा स्कूटर में आया और गाली गुफ्तार करने लगा और कहा कि दिखाकर शूट कर देता तू तो।
Revolver.
जो आरक्षक नागेंद्र मिश्रा के विरुद्ध शिकायत थाना और में थाना
2 things are remaining, my lord, that is important.
ये जो काम की चीज तो छोड़ दिया,
हाँ, revolver और
गाली गुफ्तार करने लगा और कहा कि
मैंने पढ़ा
रिवॉल्वर से शूट कर देता तू तो हिंदू और मुसलमान होता तो थप्पड़ देता।
Yes.
उसके पहले माय लॉर्ड दी कंजम्पशन ऑफ लिकर के संबंध में है।
कोई बात नहीं,
जो आरक्षक
चलो आपने बहुत अगर लीकर नहीं प्रूव तो ये व्हाट अबाउट दिस, ये तो बोला है ना कि यस
मिश्रा के विरुद्ध शिकायत थाना घनसौर में किया था। आरक्षक नागेंद्र मिश्रा ने शराब पिया था या नहीं मुझे नहीं मालूम।
राइट।
अब गाली गलौज कहाँ से हो जाएगी?
नहीं,
पहले
गाली-
चार्ज तो
गाली-
consumption of liquor का ही है।
गाली गलौज क्या जरूरी है? दारू पी के निकलती है? नहीं, फिर आपने कहा कि वहाँ कहा हो जाएगी गाली गलौज, दारू नहीं पी, या तो ये बताओ कि बिना दारू गाली दी नहीं जा सकती, फिर तो वी अंडरस्टैंड।
All these persons are my lord the complainants who have been referred by the appellant to organizing the gamble.
राइट।
उसके बाद में my lord विटनेस नंबर 5
5 का बताइए जी।
कहानी ने अपने कथनों पर बताया कि कहानी में मड़ई मेला लगा था। तभी मैं ऊपर छोटे लाल तेताम रात में 8 से 8:30 बजे घर से बाजार तरफ जा रहे थे। रास्ते में आरक्षक मिश्रा और अनाप शनाप बातें करने लगा और गाली गुफ्तार कर धक्का मुक्की किए, जिनकी शिकायत थाना प्रभारी घनसौर को किया, जिस पर मेरे हस्ताक्षर है, जो एग्जिबिट T6 है।
अच्छा चलो, ये इसने भी गाली गलौज का बोला,
ये गाली गलौज का बोला। मैं
ये आईओ क्या बोलता है?
आईओ तो बस यही है माय लॉर्ड।
ये जो साक्षी नंबर 3
साक्षी 1, 5, 6, 7 और 10
3 is
3 का बताइए जरा क्या है?
3 का
उप निरीक्षक
3 का है माय लॉर्ड।
सब इंस्पेक्टर यशवंत सिंह, ये भी आपकी अच्छी खासी सेवा कर रहा है।
नहीं माय लॉर्ड, इन फैक्ट माय लॉर्ड दी कंजम्पशन ऑफ लिकर
नहीं
इज मैन।
चलो लिखकर का छोड़ दो, आपने बिल्कुल नहीं पी रखी थी। गाली गलौज का सबने बोला।
Intentionally they have made my lord because they are complainant before the authorities.
ओके, तो देयरफॉर यू कैन से कि ये सब झूठे हैं, बाकी एलिगेशंस है।
My lord,
ये
these are the allegations.
राइट
And with malafide intentions, these allegations have been.
राइट।
During course of the inquiry, my lord, the petitioner also applied for defense assistance. That has also not been given. And in the impugned order itself, my lord, the observation by the disciplinary authority is at page 55. आरोपी आरक्षक ने अपने जवाब में शराब के
दूसरे विटनेसेस क्या मेडिकल वैसे हुआ था?
my lord,
मेडिकल हुआ था वैसे?
नहीं हुआ मैं।
अच्छा मेडिकल, ठीक।
उसी के संबंध में this issue has been considered by the learned single judge in a different case.
Right.
Based on the Supreme Court judgments, my lord. This has been, if my lord may permit, I may.
यस श्योर, क्या है? पैराग्राफ
11,
11
12, 30.
If the charge relating to consumption liter is leveled against the delinquent, then it can only be proved by medical examination, but it cannot be proved by superficial examination of the. तो ये तो इस आगे ये 11 कैसे एप्लीकेबल.
Get up to 10% off on your first flight booking. Download the Make My Trip app now.
Although in the present case, petitioner was physically and medically examined, but in the medical report, not disputed whether the doctor's opinion was not so favorable. Have you ever seen it? Oh, yes. Right. The present appeal has been filed. A bare perusal of the charge sheet. It is apparent that only one charge has been framed, but it has been divided in 3 allegations as enumerated in the charge sheet. चार्ज नंबर 1 इज ये इसका ग्राउंड्स में बी के ग्राउंड में ले रहा हिंदी का पोर्शन है. स्टॉप. इन द एंटायर हिंदी का पोर्शन करके उसको इन द एंटायर इंक्वायरी रिपोर्ट it has not been brought on record by the causant documentary evidence that any point of time the petitioner was found in intoxicated condition. Still, the inquiry officer has recorded charge number 2 is found proved merely on the basis of statement of witnesses 1, 5, 6, 7, and 10 who are annoyed with the appellant and under influence of the police authority, they made such statement. Stop. Para. The counsel appearing on behalf of the appellant submit that the writ court did not take into consideration the contradictions of the statement of such witnesses, and contrary to the record, the writ court has recorded that the appellant has not established his case before the inquiry officer. Hence, the impugned judgment passed by writ court deserves to be set aside. Stop. In addition to above, he submit that in respect to charge number 3, the inquiry officer had taken shelter of statement of departmental witnesses number 1, 4, 5, 6, 7, 8, and 10 and recorded finding that charge number 3 is found proved. Stop. A bare perusal of the statement of all the witnesses adduced by the department, it is apparent that with predetermined and malified intention, the statements have been given with ill intention against the appellant. Stop. This material fact has not been taken into consideration by learned writ court. Stop. Hence, the present appeal deserves to be allowed. Stop. Para. The writ petition was filed before the writ court, assailing the order of removal from service dated 28 August 2002, Annexure P6, and subsequent orders dated 11 January 2003, 29 April 2004, whereby appeal and mercy appeal preferred by the writ petitioners were rejected by the competent authority. Stop. The case of the writ petitioner before the writ court was that petitioner was served with a charge sheet annexure P1 dated 25th January 2002, wherein 3 charges were alleged against him. Stop. He denied the charges and therefore a department inquiry was initiated, and after recording evidence, the inquiry officer submitted a report and opined that charge number 1 has not been proved, whereas remaining charges were proved. Para. Further case of the petition was that the department inquiry and punishment are defective because the petitioner was not permitted to engage a defense assistant in the department inquiry. comma, the deposition of defense witnesses have not been considered, comma, there is a perversity in the inquiry report and the punishment is harsh and excessive. Stop. Para. On the other hand, the respondent has supported the impugned orders and submitted that there is no procedural impropriety or perversity in the department inquiry. The punishment imposed is commensurate to the misconduct committed by a member of disciplined force. Stop. And to buttress the said submissions, he placed reliance on State Bank of India and others versus Vidyut Kumar Mitra and others 2001 2 SEC 316 and Sanjay Kumar Singh versus Union of India and others 2011 14 SEC 692. Stop. Para. The Writ Court observed that scope of judicial review in cases of department inquiry is limited. There is no dispute to this said fact. Stop.